And for more on this, we are joined by Professor Stefan Talmon, who is the director of the Institute for Public International Law at the University of Bonn. Welcome, Professor, to our program. Professor, may I start by asking you, what do you make of the legality of this tribunal to begin with?
The tribunal is established under the Law of the Sea Convention, and especially its Annex 7. So all parties to the convention have accepted dispute settlement procedures as foreseen in the convention. So that is the legal basis for the tribunal's work.
However, Professor, as far as I understand, that there are different bases and foundations for different countries to participate as members of this UNCLOS.
That is right. I think we must distinguish your question of the legality or legal basis of the tribunal and the question of the tribunal's jurisdiction. The question of the tribunal's jurisdiction or its competence to hear certain cases is a different question. The tribunal is not a tribunal that can decide all kinds of questions. Its competence or jurisdiction is limited to disputes concerning the interpretation or application of the Law of the Sea Convention. And within that jurisdiction, states have the opportunity or the option to exclude certain disputes, although they are disputes concerning the interpretation or application of the Convention. And China, as you rightly mentioned, has made use of that opportunity and has especially excluded disputes concerning maritime boundary delimitation, law enforcement measures, or military measures.
Is China alone in that case?
No, of course not. There are quite a number of states which have made such declarations. This is a normal procedure under the convention. There is nothing special about this.
That has been very clearly explained by you, Professor. But in that case, why would there still be a tribunal dealing with the sovereignty issue? Why would there still be arbitration panel like this?
Generally, if one party to the Law of the Sea Convention institutes proceedings, then of course a tribunal must be established. But the first task of the tribunal is to establish its jurisdiction. Under the Law of the Sea Convention, it is the tribunal that has competence to decide on its own competence. This is the compétence de la compétence rule in international law. But while investigating its own competence, the tribunal, if it finds that the dispute is about territorial sovereignty, would have had to rule that it has no jurisdiction and to dismiss the case. Now, of course, as we all know, in October last year, the tribunal assumed jurisdiction with regard to certain of the Philippines' claims, and I and others have argued that the tribunal wrongly did so because these cases or these disputes concerned questions of territorial sovereignty and for that reason were outside the tribunal's competence.
The United Nations Convention on the Law of the Sea, or UNCLOS, is the international agreement that resulted from the Third UN Conference on the Law of the Sea, which took place between 1973 and 1982. The Law of the Sea Convention defines the rights and responsibilities of nations with respect to their use of the world's oceans, establishing guidelines for businesses, the environment, and the management of marine natural resources. The convention concluded in 1982 and came into force in 1994. According to figures released by the UN in 2008, the convention is binding for 154 states.
Is this going to be an interesting, at least, precedence? And what would that mean for future jurisdiction or possibility of jurisdiction concerning sovereignty?
I think you chose a very interesting term. You said it would be interesting, an interesting precedent. I would call it a very dangerous precedent. If tribunals assume jurisdiction over questions over which they have no jurisdiction, this will be very dangerous for all parties to the Law of the Sea Convention. If tribunals like the present one show some judicial activism and seize on questions they are not competent to rule on, this may encourage other states to try to use these tribunals also to bring cases that are not subject to the jurisdiction of these tribunals. So you could say it opens the door to the abuse of the law of the sea jurisdiction created by the Law of the Sea Convention.
What is the danger, if I could follow by using your word, Professor, of making use of international law as a geopolitical and political weapon? Will this be a case that's likely lead us to imagination about similar sort?
Yes, of course. If the tribunal in its final award would rule on questions of territorial sovereignty, countries like, for example, Argentina could use the same mechanism to bring a case against the United Kingdom to dispute the sovereignty over the Falkland Islands, Malvinas, that are disputed between the United Kingdom and Argentina. And as we all know, there are many disputes over territorial sovereignty in the various oceans or on the globe. So this would just probably be the start of quite a number of cases where states would try to use or abuse the dispute settlement mechanisms under the Law of the Sea Convention and use it to further their own aims with regard to territorial sovereignty dispute.
On the other hand, Professor Talmon, there has been a lot of different arguments concerning, for example, this territorial disputes between China and the Philippines. Many of those arguments based on the size of one party against the size of the other party, suggesting one is the weaker party while the other is the stronger party. But of course, when it comes to sovereignty, it is not necessarily going to suggest the weaker party has an upper hand or the stronger party has an upper hand when it comes to international law. So with an international law's perspective, Professor, what do you make of so-called the stronger party and the so-called weaker party, smaller party and the so-called bigger party?
I think this is just part of the overall political dispute. Law is used, as I said, it is instrumentalized, and of course a legal dispute is portrayed as a fight between David and Goliath, and of course if you do so, you want to create sympathy for David. But that has nothing to do with the legal position. As we all know, the law is generally blind, so it doesn't matter what size a country has or whether it is more important than another one. Before the law, all parties are equal, and the law is to be applied objectively to all parties. So I would see this more as a part of a strategy in a wider political game to create sympathy for one of the parties in the legal dispute, but it has nothing to do with a legal dispute as such.
How much difference, Professor, does it make when it comes to charisma of these panelists sitting on the tribunal? Many suggest the stronger personality they have, they are likely to attract attention in the court and therefore likely to win some votes, quote unquote. Others suggest that is not the case. From your experience, even though China is not participating in this tribunal, but many around the world are looking at it with a huge amount of attention. What do you make of this element?
I think this is a very important element. We should not underestimate the importance of individual judges. We are talking about a panel of 5 arbitrators. Now, these are all very experienced law of the sea judges or law of the sea practitioners or law of the sea academics. But of course, each one of them comes with its own background and its own ideas about international law and the law of the sea. And of course, these arbitrators will try to establish their view of the law of the sea as the tribunal's view. And in the deliberation of the 5 arbitrators, there might be stronger characters and weaker characters. And the strong characters might want to try to be perhaps more activist. They might have a particular view of the South China Sea dispute. They might think they could settle such a dispute, and they may take a certain position and try to convince their colleagues that theirs is the right way forward. So I don't think that all 5 arbitrators are really equal in that respect. It's like in any personal relationship. You have people with stronger character, with more charisma, and people with less charisma. And the ones who have a stronger personality will prevail at the end of the day.
Before we go, final question for you, Professor. On July the 12th, a jurisdiction will come out, the ruling will come out. Even though we have once again mentioned that China does not accept any ruling from this arbitration because it believes it was illegal to begin with, what do you think should be the advice you would provide both to China and the rest of the world, looking at the nature of the ruling of this tribunal and also its possible impact for the international law?
Considering the complexity of the disputes in the South China Sea, I think it would be wrong to think that the arbitral tribunal can provide the silver bullet to solve the dispute. I think, as we all know, China has not been participating and is not accepting the ruling of the arbitral tribunal. So I think what the states in the region have to do is to look forward. They have to find a common basis to solve their disputes. Now, if one important player like China does not accept the arbitral award, then it doesn't make sense, in my view, of the other parties to seize on that award. And we don't know yet how the award will actually go, which side it will go. As you know, there were 15 submissions by the Philippines to the tribunal. In my view, there will be not a clear winner in this case. But of course, independent of the outcome, China has already said it will not participate and it will not accept the ruling. And I think that is rightly so, because I agree that there is no jurisdiction, at least with regard to the issues concerning territorial sovereignty. And there are other problems with the award. So China, even if there are some elements that are favorable to China, will probably not rely on these because it is rejecting the award in its entirety. Now, if China is rejecting the award in its entirety, I think it is very important for the other countries in the South China Sea to leave that award behind and to look forward to find, as I said, a new common ground on which to base their negotiations to find a solution to the dispute.
Professor Stefan Talmon, thank you so much, Professor from the Institute of Public International Law at the University of Bonn. Really appreciate it. We learned a lot. Thank you, Professor. And that is all the time we have for today. If you'd like to see more of a program, visit our website. Just type in World Insights CCTV News into your search engine. You will be able to find us, or you can also check out our YouTube channel. From me, Tian Wei, and everyone at the World Insight team, thanks for watching. And tune in again tomorrow for more insights from across China and around the world. Good night.